an accused person, a convicted person, must benefit from the less severe minimum sentence. The second principle, and for the lawyers, you'll find this expounded in depth. I'm simply picking up the summary thereof. So before I go to the second principle, may I draw attention to the fact that this principle of minimum intervention is amplified and recognized in our Constitution, and I draw your attention to Article 50 of the Constitution of Kenya that says that an accused person should be given the benefit of the least severe sentence, and especially if there has been change in law in relation to that sentence between the time that accused person was charged and at the time the court is pronouncing its sentence. The second principle that we speak to is the principle of equality before the law. And what that principle speaks to is also reflected in our Constitution. And I want to draw your attention to Article 27, that in pronouncing a sentence, in meting out a sentence against an accused person, it should not be based on any of the factors stipulated under that section, which includes race, sex, color, religion, that would prejudice that accused person. I speak to these things to bring to your knowledge that these are matters the court is liable to and matters the court has considered in meting out the sentence herein. The third principle is on proportionality. And this principle on proportionality speaks to two areas. That in deciding what is the appropriate proportional sentence to give, the court will take into account the aggravating and the mitigating factors. And so I am quite alive to the fact that it will be important for the court to consider what are the aggravating factors and what are the mitigating factors. I'll be speaking to these principles later as I apply them to the matter before this court. The next principle speaks to imprisonment as the last resort. And this principle has evolved because, according to what is said to be research, it does appear that imprisonment does not even deter commission of an offense. That is the argument for those who have advanced this principle, and that the imprisonment should be the last resort. The other principle speaks to cost effectiveness. That before the court pronounces a sentence, it should stop and ask, what is the cost of, for example, if I may come back home, sentencing a person to prison, what is the economic impact to the society? And in fact, the argument behind this is that if the court finds the prisons are congested, then they might as well defer the sentence and wait for the congestion. I'm speaking to the principles that are generally, globally applicable in terms of sentencing. Let's come back home. What are the guidelines speaking to? So the sentencing guidelines at clause 1.2 guides the court to take into account the following areas in determining sentence, and the first factor is proportionality. And it states that the sentence meted out should and must be proportionate to the offending behavior, meaning that it must not be more or less in view of the gravity of the offense. The other principle or guideline under the sentencing guideline is equality, uniformity, parity, consistency, and impartiality. And I am sure even if one just picked one, that is consistency, that there should be consistency in the sentences that are meted out in relation to same or similar offenses. The sentence should speak to the principles and guidelines of accountability and transparency. The court should be able to give reasons why it has meted out the sentence that it has meted out. The other principle and guideline is inclusiveness, and this is very important. It requires the court to hear both the offender and the victim before pronounces its sentence. There is need to respect human rights and fundamental freedoms of the parties that are involved, and in this case, of course, the accused person. And finally, the sentencing guidelines requires this court to take cognizance of the need to enhance compliance with the domestic laws and international instruments, and we are all aware that Article 2, Sub-Article 5 and 6 of our Constitution requires that the court takes into account all the treaties and conventions that have been ratified that form part and parcel of the law of this country. So those are factors this court needs to address in deciding the sentence in this matter. So, but what then are the objectives of punishment? And again, I seek of your attention because this is very important. The generally accepted goals and objectives of punishment includes but are not limited to retribution. And that entails the punishing of the offender for the conduct, and that punishment be meted out in a just manner. The second objective of sentencing is deterrence. And I'm looking at deterrence in two categories, and that is basically the position. There is individual deterrence and there is general deterrence. And individual deterrence is where the offender is being deterred from committing a similar offense in future, and the general deterrence targets the public that any other person who intends to commit a similar offense should be deterred. Again, very critical. I'll be speaking to the same as I revert back to this matter. The third objective and goal of sentencing is rehabilitation. I think the word speaks for itself, whereby the sentence aims at giving the offender, the convict, an opportunity to be rehabilitated through designated, designed programs with a view that the offender can reform and be reintegrated back into the society. I'll combine the other two objectives together, and that is restorative and restitution. Those two objectives speak to the offender remedying the wrong in form of compensation, and that would take an order where the court, for example, orders that you have caused harm, and so you need to instead restitute, to bring back the victim to the position that victim was before the offense was committed. I am speaking to all these objectives because we shall be interrogating them and finding out which one is suitable in this given matter. The other goal that we need to address is community protection. And the question the court must ask is this: does the sentence that has been meted out protect the community from the offender? Denunciation. Does the sentence clearly communicate the community's condemnation of the offense? Reconciliation. Should the court order reconciliation, where the family of the victim and the family of the offender sit together and reconcile? And finally, reintegration. Is the sentence of reintegration appropriate, whereby you allow the accused person to go back and be reintegrated? And so, how does the court in the process of this trial deal with the issues, the goals, the principles? Section 216 and 239 of the Criminal Procedure Code requires this court to conduct a trial and is informed of receiving evidence at this stage. It says as follows, that is section 216 and 329. The court, before passing a sentence or making an order against an accused person under section 215, receives such evidence it thinks fit to inform itself as to the sentence or the order to be passed or made. In addressing section 216 and 326 that I've just spoken to, the Supreme Court in Murwatetu case had this to say at paragraph 43. So it said that therefore from the reading of these sections, it is without doubt that the court ought to take into account the evidence, the nature of the offense, and the circumstances in order to arrive at an appropriate sentence. And in compliance, therefore, this court directed the parties to file their submissions. And as I indicated last time, the court had the opportunity to receive, to read, and to consider the submissions by the prosecution, the victim's family, and finally, mitigation by the accused person. For the benefit of all of us, I will in a nutshell summarize what the prosecution have invited this court to take into account before meting out the sentence. Again, very briefly. The prosecution submissions are dated 6th of March 2024. Before those submissions, the court had sought for the records of the accused person. The court received the records and the accused person is indeed a first offender. That fact has been considered in this decision. My understanding of the submissions by the prosecution are that they have invited this court to look at the aggravating factors in this matter. And they have outlined them as follows, and I'll read them out. The prosecution invites this court to note that on 20th day of September 2018, the deceased Monica Nyawira Kimani lifeless body was found inside a bathtub with her throat brutally slit and hands tied. The court is invited to note that the post-mortem report produced by Dr. Peter Ndegwa confirmed that the deceased Monica Nyawira Kimani died due to severe neck injuries due to a sharp force. The court is being invited to consider that there was serious and grievous harm occasioned to the deceased. The court has been invited to consider that the weapon used was a dangerous weapon and that the offense was an intricate planning. There was intricate planning of the offense. And in capital letters, the court has been invited to note that there was no degree of provocation from the deceased person towards the offender. And finally, the court has been invited to note that after commission of the offense, there was an attempt to conceal the evidence. Not finally, there is one more. The court has been invited to consider that the crime had serious physiological and physical harm to the victim and the family. Based on these factors, the prosecution argues that this court should mete out the sentence as provided for under the law. They have invited this court to note that despite the decision in the case of Murat